Two. Hello, everyone, and welcome to this panel conversation about what would happen to Julian Assange in the United States. I'm Kevin Gostola. I'm a journalist with shadowproof.com, and I'm very honored that Courage asked me to moderate this event and to also have this discussion with these esteemed panelists that are joining us. I've been covering this, the extradition proceedings and the charges that have been brought against Julian Assange for the past couple of years, but I've also followed WikiLeaks very closely over the last decade and also done a lot of work covering the war on leaks, which is a war on whistleblowers, which is also a war on journalism and press freedom. And we'll be getting into many of those issues as they relate to what would happen to Julian Assange, the WikiLeaks founder. But now I want to bring in to this discussion the panelists. Barry Pollack is Julian Assange's attorney in the United States. Welcome, Barry. And Jeffrey Sterling is a CIA whistleblower who was convicted under the Espionage Act in the United States. Welcome, Jeffrey.
Thank you for having me.
And Lauri Love is a UK activist who successfully defeated an extradition request from the United States. So welcome, Lauri.
Thanks.
And so to begin, we're going to start with Barry. We know that you're here for an hour, and then we're going to have the other panelists for a bit longer. So that's also probably a note to people who are following along that if you have specific questions for Barry, please get those to us in the first hour so that we can ask them before he has to leave. But to begin, we decided to look at this in the different phases that would occur in this case if Julian was brought to the United States. We've got the pretrial phase, we've got the trial, and the potential conviction phase, and then if convicted, would be sentenced, and then there would be a post-trial phase. So, to begin with you, Barry, the question we wanted you to look at is the nature of this case, having the fact being so that it is involving a national security leak, so to speak, which is how the U.S. government refers to it. There are certain aspects that come into play in how prosecutors at the Justice Department pursue these cases. There's laws governing the handling of classified information. There's laws handling people who are detained for these alleged crimes. Could you address that, Barry?
Yeah, absolutely. So in some ways, this prosecution is completely unprecedented. In other ways, there is a path that has been tread before, and Jeffrey is unfortunately very well aware of that. So what is unprecedented is using the Espionage Act to prosecute a publisher or a journalist. That has never happened previously, and so there are a lot of legal issues that would come up in this case if Mr. Assange is ever extradited that have never been subject to court rulings in the past, and we don't know how they're going to come out. But we do know how classified information cases are handled in the United States. There's a law called the Classified Information Procedures Act, which deals with prosecutions involving classified information and strictly controls the use of that classified information so that it is not part of the case in open court. And oftentimes it is not even available to be shared with the defendant himself. And so one of the great challenges in defending these cases is there may be large volumes of evidence that I, as the lawyer, cannot even discuss with my own client. So that makes it extraordinarily difficult. The other thing that is very difficult is any piece of classified information that you want to use as part of the defense, you have to litigate with the court, literally page by page, line by line, identifying in advance what it is that you want to use, and then have an argument with the government about whether or not the government's going to allow you to use it. If not, if there be some substitute version that is acceptable. And what that does as a practical matter is it requires the defense to preview its case for the government, something that doesn't happen in any other federal criminal case. So there are tremendous disadvantages to a defendant trying to defend himself when the charges relate to classified information. The other aspect that you referenced, Kevin, are sort of pretrial conditions. It is almost a foregone conclusion that if Mr. Assange is extradited, that he would be detained pending trial, and he would be detained in very draconian circumstances. In all likelihood, he would be in administrative detention, and would have very little access, if any, to visitors, to email, or even to snail mail, because of the government's concerns that he has been privy to classified information. They would presumably be very concerned about him communicating with the outside world for fear that he might be passing on classified information. So from a standpoint of how he would be treated prior to trial compared to how most defendants are treated prior to trial, he might face very, very difficult conditions, and conditions that I think from anybody's mental health standpoint are just devastating, just complete isolation.
Well, when we look at the body of cases, I'll move on to Jeffrey and ask Jeffrey about what happened to him in the run-up to his trial and the way he was treated. But when we look at these different cases, what Barry is speaking about here is that you have a government that maybe no longer will allow those who are accused of these alleged acts of being outside of a jail cell prior to their trial. But I understand, Jeffrey, you weren't in a jail cell. You were able to move about and work with your attorneys, right? But in the most recent case, with like a really high profile case that I followed with Reality Winner, she was kept in jail and unable to work without being in shackles with her attorney. So that's something that we might see happen with Julian. So I'll let you speak about your case and how you were treated in pretrial phase.
Well, for me, pre-trial, once I was arrested, and again, my ordeal with the government lasted, it started in late 90s, 2000 for me. But when I was finally arrested, I was taken to the Alexandria jail to be held. That was pretty much in a cell block. It was actually the same cell block that Zacharias Moussaoui was held. Very isolated. And that really told me they were treating me like I'm a terrorist. They were believing the claims the government was making that I was going to, if I was free to go, I would go out and start assassinating CIA employees. I hadn't been able to touch the CIA in over 10 years. But the judge was believing that the Fourth Circuit, which I'm sure you're going to talk about later, will really believe everything the government says. Only after a number of weeks did it not make sense for me to be held in the jail. But I still wasn't then allowed to go home. I had a friend who came just to speak on my behalf. The judge the judge said to her, he either stays with you, and this is a friend I hadn't seen in a number of years, the family that I knew when I lived in Virginia. If he doesn't come to stay with you, then he stays in jail. It was completely ridiculous, that sentiment, but that's how this court is. Their view is that if you're a defendant, you're guilty, and we're going to do everything to isolate you and punish you until we can eventually have you tried and convicted. After that, I of course lost my job. I was able to go home after a number of months, but the isolation was then even more severe. Losing my job, but I was lucky enough to be able to be with family and friends. Mm-hmm. Mm-hmm. And for me, the other aspect of it is just the amount of time. The first search warrant, the only search warrant done at my home, I wasn't indicted until almost 5 years after that. So I had been in this limbo for so many years, and then being arrested out of the blue, thinking that this was all behind me. But the government's reach and its vengeance evidently has no time limit.
There's a little bit of similarity then with Julia's case, because there's been this cloud of investigation hanging over for quite a number of years, longer than what you've dealt with, and the uncertainty, and then finally being hit with this indictment. And so, Lauri, could you discuss what it was like, the threat of solitary confinement for you, and how the prison conditions element played into your case, or what it was like to go through what you went through, expecting that you might be put into this kind of isolation?
Yeah, sure. So this formed quite a significant backbone of our defence, because it's very hard to actually defend against extradition, because you're not allowed to speak to the charges, or the legitimacy of the charges, or the factuality of the charges, because they're all treated hypothetically. The only thing we could speak to was my health, physically and mentally, and the conditions that I would be facing in detention in the United States. And we had several expert witnesses speak to just how horrific, and I think most people imagine jail and prison to be unnice places, but they're not really capable of imagining just how bad it can be, in terms of someone who would be suffering from depression and potentially suicidal ideation. The solution, in inverted commas, to this in US carceral detention is to be put in effectively a form of solitary confinement. It's called suicide watch. You are removed from society. You have another person watching you in the cell. They're usually not a trained medical professional or even a member of staff. They're often a prisoner who's doing it for extra merits, extra points. And you can be put into horrific clothing called a suicide smock, which is kind of like a straitjacket. It's a special clothing to make it more difficult to effect a suicide. And it's been ruled by expert people, including from the United Nations, that extended solitary confinement, or even solitary confinement for brief periods, is tantamount to torture. And the other aspect was the woeful inadequacy of provision for mental health within the jail and prison system. So it was testified by someone who'd worked in the system that they often have one psychiatrist who is then covering potentially thousands of detainees. And so the ability to actually have anything resembling care or treatment is vanishing. There is only the exasperation of the situation by placing the person into effective solitary confinement. And while the prosecution attempted to argue that suicide watch is effective because people do not commit suicide on suicide watch, it's unfortunately the case that people will feign to have recovered because of how horrific it is to be in solitary, and then when they are back in the general population, they will unfortunately in some cases be successful at ending their lives. And how it was to sit in the Goldfish Bowl in Westminster Magistrates Court and being unable really to participate in that hearing, couldn't raise my hand and speak on my own account, and to have your life hypothetically reduced to basically despair and hopelessness, knowing that you will no longer be able to act meaningfully and have relationships with friends and loved ones, engage in the world in any meaningful sense, and probably spend the rest of my life in a small box. And the only way out would have been the grim prospect of committing suicide. And it was a pretty dark time in my life, having to for several months consider that eventuality.
Well, that's important. These are the dark ideas and thoughts that are probably going through Julian Assange's mind as he sits in the back there and in this glass box that I've been introduced to as an American, that we don't have in our US justice system, but that they do in that magistrate court. So I'd like to fold into this part of our discussion a question that was submitted. I'm going to direct this one to Barry, but if any others have anything to add, especially I think Jeffrey, you may have some thoughts on this as well. But Barry, we have a question. Julian Assange neither lived nor worked in the United States. What jurisdiction is the U.S. government claiming in his case? And I think maybe that's part of bringing this indictment and pursuing him in pretrial. So perhaps you can address this issue of the fact that he is not a U.S. citizen.
Yeah, no, that's one of the unprecedented and I think really frightening aspects of this prosecution. You're talking about someone who is not a U.S. citizen, who has no ties to the U.S. government, has never entered any kind of employment agreement or non-disclosure agreement with the U.S. government, who is not in the U.S., he's in the U.K., an Australian citizen in the U.K., and yet the United States claims jurisdiction over him. So that means literally the United States can and would claim jurisdiction over any journalist anywhere in the world. And the basis for that is that if you are publishing U.S. classified information, in the U.S.'s mind, you have committed offense in the United States, and the United States has jurisdiction over you. You have published their documents. And so under that theory, every journalist in the world is at risk if they publish something that the U.S. considers national defense information, meaning contrary to the interests of the United States.
Yeah, I think it speaks to the overbroad nature of how the Espionage Act is being used. My case, for instance, with regard to jurisdiction, the government did not, throughout the entire trial, establish when, where, or how I supposedly, and I was innocent of the charges, leaked this classified information. Part of their effort to claim jurisdiction was the book, the infamous book that was at the basis of the trial against me. The hairdresser of the lead FBI investigator at her salon had the book, and that was in the district for the Fourth Circuit. It is ridiculous. It's overbroad. It's, as I've said on Twitter many, many times, their use of the Espionage Act is perverse. So therefore, no one anywhere in the world, if the US is successful in extraditing Julian Assange, anyone, any journalist in the world is going to be subject to that sort of retaliation again by the US government using the Espionage Act.
And let me just say, in Jeffrey's case, because the crime occurred in the United States, the government had to at least manufacture some fig leaf of jurisdiction to prosecute the case in the Eastern District of Virginia. As Jeffrey said, they said, well, somebody bought the book in the Eastern District of Virginia. With Mr. Assange, they don't even have to do that. In the United States, venue is established, if the crime is committed abroad, venue is established in the first jurisdiction in which you set foot when you come to the United States. Well, since you're coming in custody, obviously the United States decides where to bring you. And so they picked the Eastern District of Virginia of all the districts in the country, that this is their home turf and where they wanted to prosecute the case, because wherever they bring him, there would necessarily be venue.
I can add to this as well. I was also indicted in the Eastern District of Virginia, and actually have the dubious privilege of being the only person to be facing 3 parallel extradition requests from 3 different states. So there was EDVA, New Jersey, and Southern District of New York. The one that is the most scary is the Eastern District of Virginia, and it's called the Rocket Docket, because of the remarkable efficiency at which they process cases. It's also the place where the coercive grand jury was impaneled that has resulted in Chelsea Manning being detained for over 100 days and fined exorbitant amounts, and Jeremy Hammond being pulled out of his prison sentence, and again attempted to be coerced into joining in this prosecution of Julian Assange. So the EVDA is notorious as a place where they will get their results. It's the chances of a meaningful fair trial are absolutely vanishing there, and also the exorbitant jurisdiction, which is the technical term for extraterritorial jurisdiction, is something just in the abstract to be incredibly concerned about, because attempting to police the world and police the release of information and control the internet is not good for there being fair international relations. And I would suggest that the current political trajectory of the United States means that even if there was some time when there could have been some trust that is rapidly vanishing.
Well, I'm glad that you raised this grand jury, because that the fact that that existed and was used to basically destroy, or its purpose to me has always been set up to destroy a media organization. And there was really no protest by most journalists in the way that this was being used by the Justice Department when Eric Holder was in charge, and then when it was awakened and re-upped by Jeff Sessions and then Bill Barr. And so I'd like to turn to Barry and ask about this issue of, if there is a trial, what is potentially lying ahead for anyone who wants to try and defend this in this case? Because, as you're saying, it's unprecedented what we are looking at. And we know with these Espionage Act cases, though they don't normally get the attention that they should require from our press, we know from some of the basic reporting that you don't have a public interest defense. And in fact, I know from covering Chelsea Manning's court-martial, the way in which they had to invent a way that Chelsea Manning could go on the record and give a statement about why she selected those documents and chose to disclose those documents to WikiLeaks and become a source for that organization, and to even describe trying to go to the Washington Post, to the New York Times, and even considering Politico and finding that she was rebuffed. But describing each of those and trying to give some kind of an explanation for the Afghanistan war logs, which I know is a key set of documents in this particular case, describing the collateral murder video, describing the Iraq war logs, describing these diplomatic cables, and going through and saying, how she became motivated to disclose those. But to me, I think a critical issue that needs to be brought up here is that Julian Assange is not a whistleblower, and he's not the leaker. He's the publisher, but yet to be prosecuted like a leaker or a whistleblower, he's not really going to have, he potentially could have very little opportunity to describe why he made the decision to publish those documents in a court of law because of how the Espionage Act has been prosecuted.
No, that's exactly right. The Obama administration was extraordinarily aggressive in its use of the Espionage Act and did use it to pursue whistleblowers, which was never the intent of the statute. It's a statute that was passed in World War I era to deal with foreign spies, not to deal with whistleblowers. But what has happened in Julian's case is to take that already incredibly aggressive use of the Espionage Act and take it a giant step further, which is to go after the publisher as opposed to going after the whistleblower. The way the Espionage Act has been used to date and the way that it has largely been interpreted, you're right, there is no public interest defense. You either published national defense information or you didn't, and why you did it doesn't matter. And so I have no doubt that the US government will take the position that this case is not different than prior cases and the public interest is irrelevant, and that Julian shouldn't even be allowed to describe why he published what he published. And we shouldn't even be able to show that what he published was newsworthy. And one of the ironies here is, I think that if the New York Times had published the collateral murder video, it would have won a Pulitzer Prize. And Julian Assange has published it, and he's looking at life in prison. So all of those issues are very problematic. But again, it's never been litigated in this context. We would certainly argue that the statute, if it does not have a public interest defense, has to be a violation of the First Amendment as applied to a publisher. The United States will take the position that Julian Assange doesn't have any First Amendment rights. Their view will be because he's not a US citizen, he doesn't have any rights. So just think about the irony there. They can prosecute a Australian citizen publishing in the UK, haul him back to the United States, and then say, well, because you're not a US citizen, you don't have the First Amendment rights that a US citizen would have. So all of these things are going to need to be resolved. Does he have a First Amendment right? And if he has a First Amendment right, how does that apply in the context of an espionage prosecution of a publisher? And I don't think that that will ultimately get resolved at the trial court. You've already alluded to this, Kevin. I think that's an issue that at some point is going to have to be decided by the United States Supreme Court. Hopefully not in this case, because hopefully the UK does not extradite Assange, and that this does not become a precedent for future prosecution.
This might be a good point to mention as well, that there is a cost to even getting to trial, and that's because of the incredibly strong coercive plea bargaining system of US federal criminal justice. So you will always be offered a plea bargain, and that will be a significant reduction because of the prosecutorial discretion on which charges to press and which multipliers to apply. So just to get your day in court, you will have to face far more charges, which in Julian's case would be far in excess of his lifespan. We're talking, maybe 200 years. In my case, it was 99 years. And the statistics for plea bargaining are, when I last checked, at least that 97% of defendants take the bargain. And I don't think it's because they feel guilty, it's because they're bullied into it. So the idea that there is actually, generally speaking, fair trials is a myth in the United States, because there's so much of a cost just to getting in front of that judge and jury.
Absolutely, and I think I'd like to add to this. I think a lot of the foundation for what they're doing to go after journalists and publishers at this point may have been with my trial experience. During my trial, the government won interlocutory appeal, and it finally settled the question whether journalists have any sort of protections. And the Fourth Circuit again said no. So I think that set the groundwork for, okay, we can expand the use of the Espionage Act to go after whoever we want, wherever they are. And they've certainly done that. And a good point Barry brought up about First Amendment rights. Again, this is the Fourth Circuit, which, my issues with the agency and my government started when I filed a discrimination suit against the CIA. When I worked there, they said I was too big and black to serve as an officer in their organization. The Fourth Circuit had the case, and they agreed with the government that said I had no constitutional rights because of national security. So if a US citizen to this court has no rights, no First Amendment or constitutional rights, then Julian Assange certainly will not. It's just, again, I can't emphasize enough of how one-sided this will be, especially in that court. I wasn't a human being with any sort of rights to the Fourth Circuit. I was just a means to an end of what the government wanted to do. And again, I was innocent of the charges, but that didn't matter. They just wanted to get on with it and have the government have their victory. Even though the government had the right to call the reporter in question at that moment, I think the Obama administration did not want to be that administration that put a reporter on trial and possibly jailed a reporter.
And let me just echo that sentiment. One of the worst things, apart from having to consider the rest of my life in a small box, was that the reduction of a human life to, as you say, Jeffrey, a means to an end, to set an example to others that you do not upset the bully in the playground. And that's a terrible thing to do, to take away all of the meaning of somebody's life and to just turn it into a deterrent.
Absolutely.
And so, Jeffrey, in your case, let's get into what you were going through, because it's very drawn out, and also you have this accompanying saga over whether a certain New York Times reporter is going to be hauled before the court and forced to give testimony, which delays and delays, and that delay psychologically. I mean, Lauri can talk about that in further detail, but also this delay further compounds the distress and stress of going through this case. So go ahead and give us some more detail about what it is like to be prosecuted at trial. And also, I should just clarify, when I mentioned Chelsea earlier about being able to talk about why she did what she did, that was after pleading guilty to some offenses. So it's not like you magically can find some place in the trial before you plead guilty. Most people who are whistleblowers and charged under the Espionage Act, if they get to say anything about what they did, it's after they've pled guilty and are already facing a sentence.
Well, for me, again, I worked for the CIA. I was, pardon my French, a damn good officer for the CIA, but I had the wrong skin color. So I sued them for discrimination, and as I said, it was thrown out for national security. But then years after that, I was blackballed from getting any sort of job or anything like that. So that's isolating within itself. I mean, government reprisal has no bounds. And then I'm trying to get on with my life. And then years and years later, the FBI shows up at my door with these wild accusations that I leaked information to a reporter. It was a blow and it was a shock to me. I thought I had gotten on with my life and that things were okay. And then it was just a tension. The sword of Damocles was hanging over me so long, so many years. And then when I got to the point where I thought it might be over, I'm arrested. You try to be, to live your life. You try to have good thoughts about the future. But when it's in the hands of far-reaching, overreaching U.S. government, FBI, Department of Justice, whatever presidential administration, it's hard to have any sort of sense of calm or being at ease with life, because all of a sudden it could be thrown asunder, as what happened with me. I mean, it was even so dramatic for me that I was recovering from surgery, and they used my then employer to trick me into coming to work, and that's where they staged my arrest. And so it's like a game to them, but there's a real life involved in this. And there really is no concern for that life. There is concern for, okay, this is what the government is doing, and the government is always right. So just the amount of time is incredible enough to withstand, and having that question as to if anything is going to happen, how is it going to happen? What is it going to do to my life? I went through that for years and years and years. Thankfully, I have a wonderful wife who has been with me and been supportive throughout. But not many people will have that. And I guess unique to me, I did not plea. A plea to anything that I did not do was never in question for me. I knew if I was going to be taken to trial, I was going to trial. If they're going to charge me with anything, there's going to be a trial. I mean, I'm a lawyer. I had a little faith that the law would bear this out for me, that an innocent person would not be convicted. The experience of first being tried under the Espionage Act. I fought to defend my country working in the CIA. But then to be turned around and being charged with hurting my country essentially as a spy under the Espionage Act really was a terrible feeling for me. Going through that trial was a horrible experience. And the sentence itself, the conviction, it felt as if my country said, we don't want you, we don't need you, and we're going to punish you for what you did, which I didn't do. But I did try to fight against against the CIA and against the discrimination in my country. Yet that was not the right thing to do. It was basically a show trial. Again, they never really produced any evidence of when, where, or how I did this act that they were charging me with. It was a show trial for the CIA to show how the CIA was a good organization and they did outstanding operations. And so therefore, it was even a question throughout, what the hell is all of this about? What it was about was U.S. using the Espionage Act, not for justice or for law, but for its own means of reprisal, retaliation, that sort of thing. So it's a very hurtful experience to go through, and still is, actually.
Yeah. Well, I don't know if you have anything to add, Lauri, but I've got a question for Barry, if you got anything to add to what Jeffrey just said. You might be on mute. I don't think we can hear you, Lauri. I'm not sure why. We're having a little technical issue. I'm not quite sure, but we can't hear you. So I'm going to go on and ask Barry this question and let you sort that out. So we have a question for you, Barry. So there's been a lot that has unfolded in the run-up to this extradition. There's been allegations of an espionage operation against Julian Assange while he was in the embassy. And of course, there's a parallel case unfolding in Spain where there's been depositions that have been taken. There's all sorts of treatment and abuses that mistreatment and abuses that happened outside of that over the time that he was in the Ecuador embassy in the UK. Certain allegations that could be made about the way the US Justice Department has investigated and targeted individuals who were allegedly associated with WikiLeaks. And the question that we have right here from someone who submitted it is, how might this feature in a trial? How would you try to work this in order to defend Julian Assange from prosecution under the Espionage Act?
Well, I think it's going to be far more relevant in the UK in the extradition hearing itself than it would be if the United States is successful in extradition he's brought here. In the extradition hearing, one of the issues is whether there's been an abusive process. And another issue is whether or not this is a political prosecution. And each of the things that you've just mentioned, in particular, spying on him while he was in the embassy, listening in on his conversations with his lawyers, listening in on his conversations with medical professionals, those are all things that I hope and expect the UK court will look at and will not condone and would be bases not to extradite him, because clearly the United States has not treated this as a ordinary criminal prosecution. Unfortunately, in the United States, the motivation of the prosecutors is largely irrelevant. It is very difficult to question the motivation of prosecutors and to even raise that as an issue. Some of the abuses that you have talked to, I think, will be subject to litigation, particularly if the government tries to use any evidence that has resulted from any of these activities. But I think what you'll find is that the prosecutors will represent to the court that they have not been privy to any of the UC Global surreptitiously recorded conversations of Assange, and that will end the matter. The judge will accept that representation, and there won't be any further litigation of it. So it's certainly something that I hope will be aired in the UK.
Let's move on to the sentencing phase, or what could happen to Julian if there was a successful conviction. And I'll start with Lauri, just because we had a technical glitch, and try to bring you back in to the conversation. So Lauri, there are apparent differences in the way that the United States and the UK handle these kinds of cases, and maybe you could speak to some of those differences and speak to what it's like, or what it was like for you to know that, essentially the US was threatening you with decades in prison for these offenses, that in the UK, you don't do that kind of time. You wouldn't be facing that kind of time. And if Julian was looking at time in the UK, probably he's not looking at as severe of a sentence. Are we still not getting you? Not really sure why we can't hear Lauri. This is very strange. Okay, so I'm gonna move on and turn this back to Barry and ask him if he can speak to this issue. I still don't know, Lauri, why we can't hear you. Barry or Jeffrey, can you hear Lauri? Is it just me?
I cannot hear Lauri. Kevin, I can still hear you fine.
Okay, yeah, there's something going on technically. I'm not sure.
But
Maybe
let me speak to that, because I think that is a vitally important issue. And I want to look at a little history here. If you look at the Daniel Ellsberg case, where he leaked the Pentagon Papers, an enormously important and newsworthy leak, but in my mind, kind of pales in comparison to the importance of what Julian has published. It was a historical look at the Vietnam War, as opposed to the ongoing war crimes that WikiLeaks has revealed. But in any event, Ellsberg was never convicted. But if he had been, he would have been looking at potentially probation. If he was looking at a prison sentence at all, it would have been a very modest one. The U.S. has, in the intervening years, just put sentencing on steroids to the point where the jail sentences in even run-of-the-mill cases are absolutely draconian, which is why we lead the world in prison population. And it has a tremendous chilling effect. I mean, how many people have the strength of a Snowden or a Manning to leak, knowing that if they are caught, they're not looking at probation, they're not looking at 6 months or a year in prison, they are looking at the rest of their life in a maximum security institution. And if we now extend that to a journalist, if you publish, you're looking at life in prison, journalists are going to self-censor. They're not going to publish anything that is even close to the line, anything that might be viewed unfavorably by the United States. And so it's not just their right to publish, it's the public's right to know that is going to suffer incredibly. In Jeffrey's case, under the federal sentencing guidelines, he was looking at 19 and a half to 24 years. And I suspect that Julian will be looking at substantially more than that under the sentencing guidelines.
I think you can hear me now. So
yes, we have you. Yeah, so let's let you speak to this.
Okay, so for people who don't know, I was accused of being involved in an anonymous hacktivist campaign, ironically protesting the exact problems that we've been discussing with the US federal criminal justice system after the tragic death of Aaron Swartz, who was basically hounded to death by an overreaching prosecutor for essentially nothing, borrowing too many electronic journal articles. Had I been charged in the UK, I've still not been charged in the UK, and I certainly haven't been convicted of anything, but had I been charged and convicted in the UK, my maximum liability would have been 36 months, of which half would be in detention. There would even be a possibility of a community sentence. In the United States, that 36 months became 99 years, and this kind of beggars belief. How there should even be in principle prison sentences beyond somebody's natural lifespan, is a question that people should be asking when trying to reform the justice system. But what it speaks to is the power that prosecutors have to tip the scales of justice by piling on charges, and the sentencing guidelines give so much leeway and scope to have these modifiers or power-ups, or however you want to call it, multipliers added. So if you commit a crime using a technical skill, such as some sort of hacktivism, then that is considered a reason to make the sentence longer. In my case, because they tried to extradite me to 3 different states in parallel, I could have been retried for the same offences effectively, and then it's considered a repeat offence. So you're convicted in New Jersey, you get dragged to Southern District of New York, get convicted again, suddenly you're a repeat offender, and it's twice as bad. And so it's quite horrific that they can effectively make you, in the words of the Godfather, an offer you can't refuse, by saying it's you risk your entire life. Here is the revolver, put it to your head, or you concede, you give up your right to a fair trial, and you let us win effectively by default. And in terms of the deterrent, certainly do not advise people these days to engage in activist campaigns against the United States, because I've seen too many lives ruined because of the vindictiveness of the response. And the other thing that I wanted to mention earlier is the process itself can become the punishment. So me, an innocent man, uncharged, unconvicted, 6 or 7 years of having to fear for my life, it takes a toll. And I think Jeffrey could speak to this too, and many other whistleblowers and activists who have been through this process, is that the stress is cumulative. The human physiology, we have a fight or flight reflex, and that involves adrenaline, and it's, to get away from the tiger or to beat the adversary. If you are under that fight or flight response continuously, then the stress levels build up, and in my case, it's resulted in chronic illnesses. I have really terrible skin, as you might be able to see. I have gastritis, colonitis, and the rest of my life will be impaired because of this, and that in itself is a deterrent. And again, let's just be incredibly clear about what we're talking about here. A occupying force in a voluntary war of aggression had military personnel who committed war crimes, murdered journalists in cold blood, and then publishers revealed those war crimes to the world. And now the UK judiciary is being asked whether the publisher should be served up to the very regime which was ultimately responsible for the commission of those war crimes, to establish a precedent that this is a bad thing to do. I don't think I can imagine a more serious threat to the transparency which underpins freedom and democracy in the world.
That's a very eloquent way of putting it, and it shows the disparity. We have an impunity for higher-ranking officials in the government, not just on these war crimes that you're describing, but also when it comes to leaks, by the way, where they are allowed to commit kinds of offenses that are turned into cases against lower-level government employees. And so I'd like to turn to Jeffrey, and then we'll get back to Barry with a couple questions, hopefully, before he has to go. But because we're on the part of what would happen to Julian if he was in prison, I'd like to hear from you, Jeffrey, and particularly on this issue of what treatment was like for you while you were in prison, having that experience of being someone who was convicted under the Espionage Act. And I note right now, just to set this up into a context, that the Bureau of Prisons has completely lost control of the coronavirus inside prison facilities. And maybe it wouldn't be a threat any longer after Julian is convicted, because this is something we expect to take potentially 5 to 7 years, a separate issue alone. However, prisons have always been a petri dish for the spread of diseases and viruses and allowing those to spiral out of control. Healthcare is completely horrific inside of US prisons. Perhaps one of the reasons why Julian might be able to convince an appeals court or the magistrate court that he should not be extradited, because his health would not be protected if he was brought to the US. So why don't you speak to that, your experiences? And I also know that you had a heart issue that you were trying to get attention for and were initially not taken seriously for requesting medical attention.
Yeah, absolutely. Prisons are nothing but human warehouses. You're basically tossed in for the time being of your sentence, and it's continual punishment. And for me, being in prison, healthcare is a joke. It's an aside to check up the box that they're supposed to provide. For me, I had previous heart issues prior to going to prison. When I was there, they recurred. And the attention given to it was pretty much passive. They did not care. It took the efforts of my wonderful wife, Holly, and thousands of people who barraged the prison with emails and phone calls and the eventual attention of a US senator for them to get me the health care that I needed while they're in prison. I mean, to feel so powerless to even take care of yourself. I had episodes of passing out, episodes of, clearly almost like as if I was having a heart attack, and the test did indicate I had, there was indication of a heart attack. But to the prison, that was nothing. They go out of their way to find a reason not to help you, to have the justification of their inaction. But when you confront them with their actions, they're always on the defensive. They even tried to say to my wife that I was a liar, that I was not having such conditions. They changed some of the medical records to remove the indications that I was having chronic heart issues. And so they're only on the defensive. And all you had to do was give me the medical care that I had the right to in prison, instead of having to go through all the machinations of putting pressure on you. The Bureau of Prisons, their emphasis is just punishment, put you away, and keep you there. What happens after that, they will blame the inmate, the prisoner, for that. And then when you turn to the judges who put you there, it was so tragically funny. My wife sent a note to the judge that sentenced me in the fourth EDVA, talking about the conditions, and I needed health care. She immediately said, well, she doesn't have jurisdiction. She had no problem finding jurisdiction where there was none to convict me and sentence me to prison. But when it came time for me as a human being who needed something, I was of no regard to her, as I had been previously. So the conditions there will be horrible for anyone. And even the aspect of mental health. I met with the counselor there, of course, as part of the intake. I was, of course, having some ideations of suicide and very depressed. Their answer to that was either feel better, or we're going to put you in solitary confinement. And my response to that was, so you're going to take my plea to you for help, and your answer is to put me in solitary confinement, which would make me worse. And her response was, absolutely. So it is not an environment that is going to have any sort of concern for your health and mental well-being. It is just there to house you and degrade you and continue to punish you.
Can I add to that?
Sure. Well, so Lauri, can we come back to you? I want to finish with Barry because he's got to leave
sure.
at the top of the hour, and then we'll pick up on this thought because it's really important to stick on the nature of the mass incarceration system in the United States. But we have a question here, Barry, and then I'll allow you to do closing thoughts that you may have before going. But the question is, if Julian was held under these special administrative measures before and during his trial, is there any truth to this idea that he may not have access to his legal team, or that his legal team would be banned from speaking to the press, either about the mental or physical conditions that he's going through? Are there certain limitations to which you can say about his treatment if he is put into the SAMS procedures?
Yeah. So the SAMs, the special administrative measures, which I love that phrase because it's just so Orwellian. It governs the inmate and the ability of the inmate to communicate with the outside world. It shouldn't interfere with his ability to meet with counsel, although it is very, very difficult in a case where you have large volumes of evidence, and particularly large volumes of electronic evidence, to have sufficient access to your client, and for your client to have sufficient access to electronic media to be able to review the material. And the SAMs can make that more difficult. In terms of his lawyer's ability to communicate, that's not governed by the SAMs, but in a lot of cases, the court will enter a protective order in the case, or people call it gag order, that will limit what public statements can be made about the case. Obviously, I have no idea if that's going to happen in this case or not, but that is something that courts have done in high-profile cases.
So anything you would like to say before you leave us? So you only have like 4 or 5 minutes left, Barry,
Yeah,
but
so
yeah, go ahead.
yeah, well, I mean, let me just respond to a couple of points that have been made. You talked about COVID, and what Jeffrey described, he experienced where they give you this choice. You can be honest about your mental health, and effectively that will result in solitary confinement in something that only exacerbates your mental health. Or you can lie, you can be dishonest and pretend that you don't have issues, which of course is destructive. Well, think about that in the COVID context, because that is happening all over the country. People do not want to submit to whatever social distancing regime the prison comes up with. They don't want to say that they believe that they might have been exposed, because the result of that is they end up in administrative detention. And so you have prisoners who have every incentive in the world not to honestly talk about who they've had contact with or whether they have symptoms. And that is part of the reason that COVID is out of control in prisons in this country. It's a very frightening prospect.
Well, thank you, Barry. I appreciate you sharing your insights with us during this hour. So, Lauri, I know that you wanted to add some more detail about the treatment and what you see happening to people who are sentenced, and yeah.
So I have a good friend who does a lot of prison support for political prisoners, activists in the United States, and I had a conversation with them recently, and I was shocked and appalled. And let's just say it's quite hard for me to be shocked and appalled these days. And specifically on the coronavirus, COVID, prisoners are not allowed to use hand sanitizer because they are classified as potentially alcohol that could be abused. Prisoners cannot wear masks to avoid transmission. A political prisoner had COVID-19 and felt unable to disclose it to the staff because they would have been put in segregation effectively, and that would have been deleterious, damaging to their mental health. Another story was there were some prisoners who it was known that they had COVID-19. There was an air ventilation system, a very short passage to the cells where other prisoners were, and a complaint was made about this, and there was no attempt to do anything. And these are not exceptions. The general pattern, as Jeffrey told us, in the Bureau of Prisons is there are procedures for making complaints and seeking redress. They are, I would say, Kafkaesque, not just Kafkaesque, but also catch-22, because simply by trying to seek to improve something, you get yourself put on a shit list effectively, and you will be bullied systematically just for trying to resolve a grievance or to try and correct some mistreatment. And if you want to find out more about this, someone to speak to is Barrett Brown, who's another information activist who was detained and went through quite a lot of wrangling with the Bureau of Prisons, trying to fix some of the mistreatment that he received, and no success at all. And so we see this all the time, that I'm just going to lay my cards on the table. I'm an abolitionist, and this is a sentiment that's growing, that I think prisons are a testament to failure of society. They are a place where somebody cannot be treated as a human, because it is effectively you become an animal, as Jeffrey said. You become subhuman when you're in that system, and we know from quite notorious psychological experiments, the Stanford Prison Experiment, that the minute you create this division between the detainees and the officers or the people staffing the prison, even if they are the best, even if they're the most moral person at heart, they inevitably begin treating these people as less than human. It's just an artifact of the way the system is structurally composed. And so this is bad enough if you're in a short time. If you are looking at spending the rest of your life there, then there's no other way of describing it except as protracted torture.
Mm-hmm.
Kevin, I am going to have to sign off, but I wanted to thank you very much for leading this important discussion. Thanks, Lauri and Jeffrey, and I hope the dialogue will continue. Thank you.
And, unfortunately, I see a question that probably should have been posed to Barry. Nonetheless, I think Jeffrey and Lauri will be able to handle it, and I'll be able to give some of my thoughts. So I wanted to note that we've had a superseding indictment that has been issued against Julian Assange, and it has at least expanded the timeline of the case, and it's upped the effect, the sort of character assassination that the Justice Department is after in their case. I do actually think that this, I'll start with Lauri on this, because it does seem that this new indictment, in their description why there aren't any charges, what they're directly trying to do is make Julian out to be a hacker so that they can use that to their advantage in prosecuting him under the Espionage Act and pretend like he is not owed the First Amendment rights or the press freedom protections that are recognized the world over. What would you have to say to that, Lauri?
So I mean, people watching may not know the differences between the legal systems, but in the UK, the idea of publishing publicly an indictment where the charges are laid out is unthinkable, just because it must have an effect of prejudicing people. And as you say, it is a character assassination. There is no way for Julian to challenge the assertions made in these indictments, and so they effectively steal a march in terms of the public perception of the case. And we have all these protections for people that are on the jury to try and stop them from being exposed to information that will prejudice them, but there's no way you could form a jury of 12 people that have not already had formed an opinion of Julian Assange based on 7 years or maybe 5 years of persistent character assassination, sadly aided and abetted by people in the journalism industry, which is to their eternal shame, in my opinion. The other problem procedurally is, again, in a very Kafkaesque manner, the UK-US extradition system proceeds in an entirely evidence-free manner. And what I mean by that is this is exceptional. No other extradition relation in the world has this, and the UK does not have this for any other country, but the United States has no requirement to meet any evidentiary bar to prove anything to any standard. The usual standard is what's called prima facie, which is on the face of it something that would convince a reasonable person that there is something to suspect, if not to be convinced beyond reasonable doubt. This does not have to be met, and from my personal experience, the claims were made in the indictments that were not just untrue, they were meaningless. They were so far removed from facts that they're not even sensible, and to have to sit in that court being lied about and being unable to say, stop, this is not true, I object. And on one occasion I actually halted proceedings, dragged all the journalists out and explained to them that they were being lied to and there's nothing I can do about it, and some of them were quite surprised by that. And what's happened with this latest superseding indictment is hopefully it will convince the judges that they have really pushed too far and have what's the polite euphemism, taken the mickey, shall we say, because they may have to drop the request after Julian has been in Belmarsh prison now for nearly a year, and put in an entirely new extradition request to have these charges entered into the record, because they've left it so late, and that's another abuse because it draws out the process even further. And yeah, it's deeply troubling from many points of view that that this ability to enter things into the public record that are not able to be challenged, and to then pretend that there is going to be a fair process at trial is morally and intellectually dishonest.
Jeffrey, would you like to add anything?
Yeah, well, I think the new round of the indictments that they produced was really just to show it is character assassination. They have to attack Julian. They have to portray him as a terrorist to justify this extraordinary measures being taken to try him under the Espionage Act. During my proceeding, The point that they were making over and over again was that I lost my discrimination suit. So I was a disgruntled employee trying to get back at the CIA by leaking classified information. Nothing was further from the truth. One thing the prosecutors didn't want the jury to realize was that during the time that I supposedly leaked this information, my discrimination case was still going on. It was still in the courts. But they didn't want the jury to know that. They wanted to have the impression that I lost, which I didn't. The court said I couldn't go forward because it posed a threat to national security. And then my trial basically turned into that discrimination case that I tried to bring before the courts, but it was completely one-sided because the government was allowed to have every description of me in, of course, a bad light from employees at the agency, but I wasn't able to counter any of that with any evidence or anything because of the national security aspect and the CIPA restrictions that I was facing. So it's incredibly unfair. It's a system that doesn't make any sense. So they have to characterize Assange as one of the most evil persons in the world. So maybe the courts there will agree with it and go through with the extradition. Hopefully, as you said, they will see through that smokescreen.
And I think it really speaks to, it betrays really that they know they don't have a case, that they have to play these dirty tricks. And it just adds to the information asymmetry. We were talking earlier about in any cases where there is digital information, then there will be vast amounts of evidence entered into the records, and if you're not able meaningfully to assess that, then you're trying to fight with both your hands tied behind your back. And in my case and in Jeffrey's, we were able to have legal meetings and conferences and to engage in campaigning and other efforts to try and fight our cases. Julian doesn't have that ability. He is detained in Belmarsh prison in not very pleasant conditions. His mental and physical health is deteriorating. He cannot speak to these latest allegations. He cannot speak to much at all. Even his access to lawyers here is, I would say, a joke. He's barely been able to see them in the last 4 or 5 months. This would just be much worse in the United States. So there would be no fairness. The prosecutors have all of the power. They have all of the information. They have, as was mentioned earlier, the judges defer to them far more than they will defer to claims from the defense. And so I think even though there's an important legal principle to be settled as regards the Espionage Act, and part of the purpose of law is treating these problems and coming to a conclusion, I think this case is not the right case for it, because it will be fought so unfairly that it risks setting a terrible precedent.
Yeah, I think that raises the issue of how heavily politicized this case is. Although I suppose it gets into the question of whether, cases are ever not politicized. I mean, you could argue that there were politics involved in your case, Jeffrey, but to a degree right now with Donald Trump and his administration, I know that the legal team is making this argument that, Donald Trump and Bill Barr have so compromised the Justice Department in the way that they're pursuing this case, that the politics alone, I mean, this is one of the few ways that they think they might be able to challenge the extradition, but they're highlighting the politicization of the Justice Department. I don't know. I mean, being that you were a target of the Justice Department, do you have any comments on how political this case is just on its face?
I think it's completely motivated by politics. Again, the desire to get Julian Assange for what he supposedly did to the United States. During my trial, during my experience and my ordeal, there were other individuals who there are far more evidence, and even they're admitting to wrongdoing, to leaking classified information. General Petraeus, great example. But individuals who are seated highly within the government receive nothing more than slaps on the wrist. They don't have to go through the same sort of ordeal. Individuals like General Cartwright, who ironically leaked information regarding Iranian operations, which is what I was convicted under, yet he is given a full pardon by the Obama administration. So yes, there is absolutely political aspects to this. You're going after the, as you said earlier, the lower individuals with a deadly fervor, if you will, yet individuals who are highly placed may have a good position within the party or within an administration. They are treated with kid gloves. And I think we've seen a little bit of that politicalization in the previous sessions. I was quite offended when the Queen's Counsel raised my name, and I believe Manning's and Reality Winner, as to quell any concerns about the amount of time that Julian could be sentenced to, by saying that the 42 months I had were the benchmark for what he would be facing. I was offended by that because you're going to use an injustice of a trial, a travesty of a trial, to say as a benchmark to what Julian is facing. It was laughable in the most tragic sort of way. And I think they're trying to do everything they can to, from the character assassination to saying, oh, we're going to treat Julian quite well here under trial with all the rights that we decide to give him. I think it's all showing that the basis for going after Julian is completely one-sided and completely immoral, if you will, for them to go after Julian Assange using the Espionage Act. They have to do everything they can to make themselves to seem not as a bad guy in this situation. And I think it's quite telling and quite political.
There's a saying, I think maybe from Turkey originally, but that the fish rots from the head, and I think that's what we're seeing here, is that there is complete impunity to leak. In fact, a lot of the narrative in the press is done by selective, systematic leaking, sometimes of classified information. So whenever you see a reporting about Washington politics and it says sources say, then that is usually someone who is leaking to set a particular narrative. And the pattern that we've seen in all of these cases and all the people we've discussed, it's been people trying to fix a problem. Chelsea Manning acting on her conscience, having seen
to wrap this discussion, that they used WikiLeaks and then later the disclosures from NSA whistleblower Edward Snowden as a catalyst to clamp down on the ability of government employees and contractor personnel to speak to the media, to control their interactions, to enforce ignorance about the information that was being disclosed by WikiLeaks, but to also use it to set up a system in which senior officials are allowed to engage in leaks, but the lower level people are criminalized if they're caught talking to members of the press. And that's, I think, comes back to the case against Julian Assange. It's an effort to enforce and create this normal and defend this normal of saying that we're not going to allow journalists to publish this kind of information. And they're using the sources of information as deterrence by going after them. And then now they're escalating it to going after the publishers. So saying even to the sources that if you give information to people who are like Julian Assange, look at what you've done. You have now made them targets who we are going to destroy their lives systematically and irreparably so that they can never come back from us focusing our crosshairs on them. And I think, we have a realistic sense of what could happen with this extradition case, but we also have idealism too about what we can do if we struggle and fight and show support for Julian Assange so that we don't see a precedent set. And that brings me to, I think, our final questions, which I have two here that have been submitted. I'm going to fold them together, and then both of you will have an opportunity to comment, and we'll wrap the discussion for this afternoon. But essentially, looking at this question of what happens if the extradition, so as we see this unfolding in a realistic sense, you really feel like it's ordained, like there's really no way that it's going to be avoided because, for one, this judge, Vanessa Baretzer, has a pretty solid record, 96% of the time, I think, of approving these extraditions. So mostly a rubber stamp. you look to the appeals process and say that's probably the best hope that Julian has of avoiding this. But then, in a hopeful sense, I think we'll start with you, Lauri, here. What happens if Julian walks out? I mean, what happened to you when you were able to know that you had beat this? Did it mean that you had defeated the US government and that you didn't have any threat anymore? Or does it mean that you just survived this round and there could be another one coming soon from the US government?
Sure. I mean, so somebody else also asked, what's my ability to travel? And there's nothing legally stopping me leaving the country. But I know that the minute I set foot in another legal jurisdiction, there's nothing stopping the United States sending another extradition request. So I have family in Finland. I haven't felt confident to go there, even though the protections against extradition are much stronger. I would be afraid to go anywhere in Europe. If I was somewhere a little further abroad, I don't think they'd even use the legal process. The US government has straight up snatched people from airports in places like Thailand and Vietnam. In terms of the rubber stamping, I am afraid to say the process is incredibly one-sided and in favor of extradition to the United States. Somebody asked what needs to be proven. As I mentioned earlier, none of the assertions and the allegations in the indictments need to be proven. They are all treated as hypothetical. So the actual scope to defend is very limited, and that's why my defense was based upon my health. And somebody else spoke to that. We had to establish. We had to make it incredibly clear what the risk was, that I would come to an untimely end in detention, and there are overlaps. It's not for me to speak to Julian's condition, but there are certainly similarities in, let's say, the character type between us, and I think that will form a part of the defence. And you can only fight the things that you're allowed to speak to, and so it will come down to the conditions and the health, and then there's the question of dual criminality, which is that is the offence the same in the UK as the United States, and we don't have an espionage act or anything really close to that, so that's something that might be argued. And I would add that, speaking again to the sentencing differences, can you really say it's the same offence when you would spend a very short time in this country in prison for it and you would spend the rest of your life in prison for it? And I would say that that's sometimes a quantitative difference can become a qualitative difference, and certainly as a deterrent to discourage people from acting on their conscience. And all of the people we've spoken about have acted on their conscience. In my case, when I look back on it, it's not the effect it's had on me that would put me off repeating it. It's the effect that it had on my family and my friends, and putting them through the hell of having to worry that they would never see their son, their friend, their lover again. To be locked up for the rest of your life in the country where you have family is bad enough, where people can visit you. If Julian was extradited to the United States and detained for long periods, his family would not be able to visit because they wouldn't be allowed into the United States because they're family of someone who's been convicted of an espionage offence. So this further removal from society just aggravates the horrificness of it. But I don't want to. We've said a lot of kind of sad things. I want to kind of turn it around a little bit towards the end here and talk about the strength that we do have, and that is solidarity. And I've really started to see it grow again through the efforts of the campaigners, and we're seeing a lot of organizations starting to really see the bigger picture here, especially amongst journalists who for a while were tricked into treating this as some kind of sordid soap opera when Julian was in the embassy, and reducing it to a kind of mockery. Now they're starting to see that actually maybe some of them entered the field of journalism because they really believe in the power of truth to make the world a better place, and starting to see that if the precedent is set that publishing war crimes and abuses will result in you being punished horrifically and spending the rest of your life in conditions of torture, then that means that their profession is not safe and meaningful and true in the way that we used to believe it was.
Jeffrey?
Yeah, there's so many things to talk about with regard to all this. It's extraordinary moves by, shamefully, my government in their efforts to quash dissent and a free press. And one thing I want to bring up that I hadn't yet, forgive me for that, the other aspect of the one-sided nature of being on trial in the Eastern District of Virginia, every member of the jury that I had some connection. Either they had a previous government job or they had a family member who at one point had security clearances. So that within itself will be against Assange if it goes that far. These are individuals who have taken the oath with their security clearances and know, especially with the retaliation going against whistleblowers, especially in the national security realm. And so there's an automatic fear. They better go along with what the government is saying and not think about it, because then maybe they'll feel they will be next, sort of thing. So it is an incredibly one-sided aspect for them. I mean, there's also the truth that the US government will not have to prove any harm or any damage under being a trial for the Espionage Act. So I think it's rather false and shows the politicalization for them to even mention any harmful aspects during the proceedings there in the UK. And that's so extraordinary. You're taking a man's life, but you don't have to prove what harm he did. And that's what they're doing. So there won't be any discussion about the good that came from Julian Assange's disclosures. But the government won't have to talk about any damage. So what is the point of them wanting to try him other than to punish him, to retaliate against him, and to serve, as an example for anyone else who has any ideation of going against the US government or doing anything to embarrass the US government. The Espionage Act is being used as nothing more than a tool to prevent embarrassment for the US government.
Can I add to that? Sorry.
Sure, go for it.
Because we've spoken so much to how unfair the process will be judicially in the United States and even in the extradition process here in the UK, it underlines the importance of what we're doing today, which is informing the public. Because even though in theory judges are not swayed by public sentiment, in practice, when the more people know and understand this situation, the more viscerally they feel the injustice of it, then the harder it is for the judges, hopefully at the Court of Appeals here in the United Kingdom, to do the wrong thing. And the fact that I'm here today and not in a small concrete box somewhere in Virginia is testament to the fact that you can win. It was groundbreaking. It was a precedent. It's the first time someone has successfully argued that the United States does not have this extraterritorial jurisdiction, that the correct forum was the UK. And so it can be done. We just have to believe in the possibility, and then work tirelessly to manifest that through educating and informing the public.
Well, I'd like to wind down this discussion that we had and acknowledge that as a backdrop, we see a total crisis of legitimacy, government to government, not just in one particular region, but throughout the world. But because I'm a part of this region, I will particularly direct my attention to Western countries as they're typically described, US, North American, and European countries, this crisis of legitimacy. And if there's anything we can do to help Julian Assange, it's to seize upon this moment in which people have lost faith in the ability of those governments to deal with corruption, and celebrate and try and protect an individual who set up an organization under this banner that it could be an intelligence agency of the people, so to speak, believing that it could harness the power of information and help us gain a better knowledge and insight into the way our governments were concealing corruption and abuses from us. And which is why it is crucial and critical for people to be building this solidarity. I thank Lauri for the note that he ended with, because there is reasons to believe that you can create a cost for these governments if they go forward with this. I acknowledge right now that Julian Assange is still in a jail cell, unfortunately, trapped there while COVID continues to spread. And I think that that makes what we're doing here today have much higher stakes and much more importance, because he's not just on home confinement, but he also faces this threat to his health inside of the Belmarsh prison. So as we conclude, thank you, Barry, for joining. He had to leave earlier. Thank you, Jeffrey, for being part of this conversation. And thank you, Lauri, for being part of this conversation. I'll note that this was organized by the Courage Foundation, which campaigns for Julian Assange's defense. And you can go to defend.wikileaks.org, defend.wikileaks.org for further information. For now, thank you, everyone.
Thank you.